had been taken, such as establishing a Human Rights Commission and appointing the country's first ever female judges. This process was accelerated by the introduction of the reform agenda by President Maumoon Abdul Qayyum in 2004. It is noteworthy that considerable progress has been achieved in guaranteeing the fundamental freedoms and individual liberties of all within Maldivian society. In 2008, the Maldives introduced a new democratic constitution which contains a strong Bill of Rights. Since the introduction of the reform agenda, and particularly since the adoption of the constitution, the country has taken a number of important steps relevant to the enjoyment of civil and political rights. It has held its first ever free and fair multi-party elections, has removed the gender bar from running for the presidency, has established a range of independent oversight bodies, including a Judicial Service Commission and a Police Integrity Commission, has established a Prosecutor General Office, and has taken steps to create a fully independent judiciary. President Dr. Mohammad Wahid Hassan has recently enacted anti-domestic violence legislation, an important bill which secured cross-party support. Notwithstanding these important changes brought in with the new constitution, it is an unfortunate fact that very few legislative bills needed to implement these new rights and principles have been adopted. Many crucial pieces of legislation foreseen in the reform agenda remain at the drafting and negotiation stage. This includes a range of bills needed for the effective functioning of the judicial and legal systems, a Freedom of Information Bill, a new Prison and Parole Bill, a Bill on Equality and Non-Discrimination, a Sexual Harassment Bill, a revised Children's Rights Act, a Bill on Mental Health, a Bill on Freedom of Assembly, and a Bill on Trafficking in Persons. A further challenge is that institutional capacity of the wide range of new independent oversight bodies has not kept pace with the societal changes brought in with the new constitution. The rapid nature of the country's democratic transition has left many such bodies, including crucial institutions such as Human Rights Commission of the Maldives, struggling to keep up. As a result of these bodies have not been able to deliver as expected by the public on the important mandate each of them holds in the country's delicate system of checks and balances. The newly independent judiciary also faces significant capacity constraints. In the international field, while the Maldives has made considerable progress in ratifying and reporting on key human rights conventions, its implementation of its obligation and commitments need further strengthening. President Wahid has begun the process of reconvening the country's UPR Stand-in Committee to oversee implementation. The Maldives' ongoing democratic transition and the related blossoming of human rights are homegrown achievements. However, this transition also reflects a strong and effective partnership that has evolved over the past years between the Maldives and the international human rights community. In this regard, we value this review by the committee as we believe that domestic implementation of the rights protected under the ICCPR is an area where far more progress is needed. We are confident that this meeting will positively contribute to the strengthening of the national human rights framework of the country. Distinguished members of the committee, before I proceed, let me introduce my delegation today. I have with me His Excellency Dunia Maumoon, Minister of State for Foreign Affairs, and His Excellency Ms. Irtisham Adam, our permanent representative in Geneva. It is my intention to use my opening statement to give an overview of the human rights situation in the Maldives, as well as developments since the Maldives tabled its national report and since the committee sent us its list of issues. Distinguished members of the committee, as you will be aware, 2012 has seen significant changes in the Maldives, and these have clear implications for the rights protected under the covenant. In mid-January this year, the army arrested and abducted the head judge of the criminal court, Judge Abdullah Muhammad. When then President Mr. Muhammad Nasheed refused to recognize the orders of the Supreme Court to release the judge, a series of nightly protests began against his government. Eventually, on the 7th of February 2012, President Mohammad Nasheed resigned from office. Article 121 of the Constitution of the Maldives provides that the President may resign from office by sending a letter of resignation to the Speaker of the People's Majlis or the Parliament, and that the office shall become vacant when the letter of resignation is received by the Speaker. Article 112E of the Constitution provides that if the office of the President become vacant for any reason, the Vice President shall succeed to that office. It was in accordance with this procedure that the then Vice President, Dr. Muhammad Wahid, succeeded to the office of the President on the 7th of February. As per the Maldives presidential system of government, both Mr. Nasheed and Dr. Wahid were elected by popular vote on a joint ticket and on a common policy platform in the 2008 election. Thus, President Nasheed's resignation and President Wahid's elevation did not in fact constitute a change in government, but rather a continuation of the democratically elected government. Notwithstanding these legal facts, there is disagreement in the Maldives about the exact nature and sequence of events that led to former President Nasheed's resignation. This has led President Nasheed and his supporters to question the legitimacy of the current administration and has served to perpetuate political tensions within the country. In order to help resolve these questions and divisions, President Wahid established a Commission of National Inquiry as an independent and impartial body with the mandate to investigate events that led to resignation of Mr. Nasheed and the subsequent transfer of power to Dr. Wahid. The CONI, as it is known, is also mandated to investigate events from 14th January to 8th February to help to establish accountability for any human rights violations which may have taken place and thus set the groundwork for national reconciliation and dialogue. The CONI is currently conducting its work in complete independence from the executive and government. Domestic and for the mechanism to be genuinely independent and impartial, the government has reached an agreement with the Commonwealth to better focus the scope of the inquiry, strengthen the powers of the Commission, and broaden its composition, with the participation of an international co-chair plus a nominee of former President Nasheed. Although the CONI is fully independent and thus not answerable to the government has nonetheless made clear its wishes that the process be completed expeditiously. The CONI is now expected to deliver its findings by the end of August. Upon taking office, President Wahid has also published a roadmap containing a series of commitments designed to resolve challenges relating to governance, the judiciary, the social system, and to help bring calm and consolidate our fragile democracy. His commitments include the restoration of public confidence in democratic institutions by holding the rule of law, the establishment of a national unity government, adherence to the Constitution, respect for human rights, the continuation of efforts to reform the judiciary, the safeguarding of media freedom, and a commitment to free and fair elections in 2013. The government also agreed to hold all-party talks to try to find solutions to current political problems through dialogue. The CONI, the roadmap, and the all-party talks are three key pillars of the government's attempt to respond to the events of 2012. During the course of the next 2 days, I will be pleased to discuss progress in implementing these pillars. Distinguished members of the committee, despite these steps, political tensions remain high in the country. However, efforts are being taken to encourage dialogue and build consensus on contentious issues, and as a result of these efforts, Maldivians have been able to enjoy their daily lives as normal. The day after his resignation, former President Nasheed claimed that he had been forced to resign. Since then, his supporters have been regularly protesting in Male, the capital of the Maldives, and elsewhere. Often the protests have been far from peaceful. As we speak, protests are taking place in the capital Male, which have seen the government ministers targeted. For example, last night, the gender minister's car was torched, which have seen 6 police officers seriously injured, and which have seen journalists receiving head wounds. Such violent protests are making normal life in the capital almost impossible. However, despite this, minimum force has been used and police are showing maximum restraint. Law enforcement agencies of the Maldives have been taking all required actions to ensure the safety and security of the citizens of the Maldives. Nevertheless, MDP activists continued to harass their fellow citizens by protesting on the streets at night and also during odd hours of the day. The government would like to make it clear that it opposes all acts of violence, and the protests that have been happening recently are violent in nature. Thus, the restrictions we have placed on them are in compliance with the domestic law, notably the regulation on freedom of assembly, and with international human rights law, in particular the ICCPR. The dispersal of crowds and the actions of law enforcement officials have been in accordance with the domestic law. Any allegations made regarding the use of excessive force on occasions such as with the events of 8th of February need to be ascertained by the relevant domestic mechanism. It is also within the legal and moral obligations of the law enforcement agencies to safeguard civilians during public protests and to ensure that individual acts within the boundaries of peaceful assembly. Distinguished members of the committee, I would now like to offer a brief overview of Maldives' progress in implementing our obligations under the ICCPR. The Maldives acceded to ICCPR and its first optional protocol on the 19th September 2006. The ICCPR and its first optional protocol came into force for Maldives on 19 December 2006. The Maldives' initial report under ICCPR was prepared in accordance with Article 40 of the Covenant, which is addressed by the core document submitted by Maldives, which covers from January 2007 to January 2010. We understand that there has been some uncertainty as to the written report represented by the Maldives, which is based on a common core document and a short treaty-specific document to be cross-referenced with the CCD. On this point, I would just say that the Maldives has adopted this approach in order to improve our treaty reporting performance, which has been characterized by significant delays. The Maldives is a small island developing state with very limited capacity to prepare reports under the 8 human rights conventions to which we are now party. I would also point out that the common core document and treaty-specific report were prepared with the support of the OHCHR, which stationed a human rights advisor in the Maldives to advise the government on this matter. Ladies and gentlemen, as I have mentioned, the Maldives adopted a new constitution in 2008, which is exemplary by international standards in area of human rights safeguards. Article 93 of the Constitution requires international legal instruments to be incorporated into national legislation for them to be applicable in the Maldives, meaning that international legal instruments, including those previously ratified, will now need to be supported by separate domestic legislation. Although this does not affect the legal obligation of the state, such legislation is needed to ensure full compliance with international standards within the country. For example, in order to bring anti-terrorism legislation more closely into line with the Maldives' obligations under international human rights law, including the ICCPR, a new anti-terrorism bill was drafted in 2008. This bill is currently being reviewed by the Attorney General's office. Furthermore, a new penal code has also been drafted with the international assistance, which, in the context of implementing the Maldives' obligations under the ICCPR, will represent a significant improvement to the existing code. The new draft penal code has unfortunately been held up in the People Majlis for some years. This is a significant problem for the justice sector as a whole. The administration of President Dr. Muhammad Wahid Hassan hopes to see the new code ratified before the next election. The Maldives has also taken steps to implement the equality and non-discrimination provisions of the ICCPR. The Maldives has made significant progress on gender equality and the empowerment of women. The government of His Excellency President Muhammad Wahid Hassan has decided to again re-elevate gender equality issues to ministerial level, creating a new Minister of Gender, Family and Human Rights. This new ministry is responsible for equality and non-discrimination issues for all vulnerable population groups. The Maldives has national gender equality policy, which aims to promote substantive equality through a dual approach, mainstreaming in all areas and strategic action on empowerment and advancement in specific sectors. The country is also working on specific domestic legislation to implement the rights and obligations contained in the CEDAW. In 2012, President Dr. Wahid enacted the Domestic Violence Act, which had cross-party support in the Majlis. Regarding trafficking and contemporary forms of slavery, the Constitution prohibits forced labor. Since its recent transition to democracy, the Maldives has taken a clear stance on preventing torture and ill treatment in prisons and other places of detention. Article 16, Section 45 and 46 provides detailed provisions and safeguards to prevent torture. No one has so far submitted a case before the courts citing these provisions to test the local process. Following the Maldives' ratification of the optional protocol to the Convention Against Torture, a national preventive mechanism was established within the Human Rights Commission to undertake regular visits to prisons, police detention centers, drug rehabilitation centers, and other places of detention. During 2009, the NPM undertook 13 visits to places of detention in the Maldives and published a number of reports in 2012. While all Maldives prisons now meet minimum standard recommended by NPM, the reports published offer a picture of prison system which is struggling to cope with the pressures placed upon it. Inadequate prison facilities, training, procedures, and discipline undermine the rights and welfare of inmates and also put prison officers at risk. Despite capacity constraints which continue to hamper efforts to improve facilities, the current government is pushing ahead with improvements. For example, the major prison, Mafushi Jail, has been renovated and work on 2 new prison blocks has been tendered. The government has segregated inmates based on gender and the type of offences. Prison officer ranks now have to be approved by the Civil Service Commission. Parole, rehabilitation and reintegration programs have been restored, and training programs for prison officers have been reconstituted. Regarding rehabilitation and reintegration, the 2012 parole system was abandoned in favor of the Second Chance program initiated by the former President Nasheed. But since the new administration came into office, the parole system has been reinstated with more emphasis on rehabilitation and reintegrating prisoners. The Prison and Parole Bill, which is expected to be tabled shortly, is seen as a vital tool in improving the situation in the Maldives jail. It is expected to modernize and rationalize the prison system, placing a far higher emphasis on rehabilitation. Turning to freedom of religion, as stated in the Common Core document, Maldivian law does not provide for freedom of religion, although in practice foreigners are allowed to practice religions other than Islam in private. The Maldives maintains a reservation to Article 18 of the Covenant on Civil and Political Rights, and there are no plans to withdraw it. As noted by the Special Rapporteur on Freedom of Religion, being a Maldivian and being a Muslim have become interlinked and inseparable. There is strong public support for Maldives being and remaining a 100% Muslim country. Notwithstanding, non-Muslim foreign residents are allowed to practice other religions privately. On the right to freedom of assembly, this right without prior permission is now enshrined in Maldivian law. We have seen over the recent years increase in number of demonstrations and rallies on a wide range of different issues and involving a wide range of different interest groups. Protests take place all day and every day in the capital Male, and law enforcement personnel are allowing them to proceed in line with the constitutional rights of all Maldivians to freedom of assembly. That said, like in all other areas, there continue to be challenges. One is to exercise these rights responsibly. Unfortunately, some groups and sections of the society are promoting the idea that freedom of assembly is absolute and can take place with little or no regard to the rights and well-being of others. Political demonstrations are often held late at night, thus disturbing other members of the public without due notification to the relevant authorities and in areas not suitable for large gatherings of people. Underpinned by the new constitution and new legislation, press freedom has also improved markedly in the Maldives in recent years. However, as we look to strengthen our new democracy, it is clear that there is much more to do in this area. The Maldives now has a Media Council Act that establishes the Council as an independent and self-regulatory body. In May 2012, President Wahid handed over the control of Maldives National Broadcasting Corporation to the Maldives Broadcasting Corporation, hence removing the executive influence over the public broadcasting, which the former government insisted on keeping under its control. The new administration is also doing all it can before the next general election to ensure that journalists are provided with both the space and the security to do their work. Ladies and gentlemen, I hope I have provided the committee with a sense of the progress achieved and the challenges faced by the Maldives in implementing the rights and freedoms enshrined in ICCPR. Issues which I have not covered will be addressed, I am sure, during the interaction dialogue with the committee. With your permission, Madam Chair, I will now give the floor to my colleague, the Maldives Distinguished Permanent Representative in Geneva, His Excellency Ms. Irtisham Adam, to give a summary of the Maldives' response to the committee's list of issues. We apologize for this response being transmitted too late to be translated into all UN languages. I thank you.
Thank you, and distinguished Minister. Madam Chairperson, distinguished members of the committee, ladies and gentlemen. I am honored to now present an overview of the Maldives government's response to the committee's list of issues submitted to the committee on the 25th of June. I hope this will provide a realistic and honest account of the current situation in the Maldives with regard to civil and political rights. Constitutional and legal framework. As highlighted in the response document, in the Maldives, the rights contained in the ICCPR are not directly applicable, but rather are implemented through the country's constitution and relevant secondary legislation. The vast majority of the rights enshrined in the Covenant are protected by the Constitution of 2008, and remedies are available for the breach of constitutional rights. Furthermore, the new Constitution of 2008 established the Human Rights Commission of Maldives, first introduced in 2003 as an independent constitutional entity. The Human Rights Commission possesses strong guarantees of independence in line with the Paris Principles. It has the authority both to promote human rights and to investigate any complaint of their violation. In addition, the Commission serves as the national preventative mechanism under the optional protocol to the Convention Against Torture. The government values the work of the Commission and is committed to ensuring its financial independence. Notwithstanding, we believe the Commission already possesses the human and financial resources it needs. The Human Rights Commission's budget currently stands at the equivalent of $1.4 million and has a staff of more than 50 officials. Regarding the committee's question on the limitation of Human Rights Commission membership to individuals of Islamic faith, I take this opportunity to point out that as the state religion of Maldives is Islam, it is unlikely that this clause of the Human Rights Act will be deleted, as the Maldives Constitution stipulates all Maldivians to be a Muslim. With regard to combating terrorism, the Maldives, like all states, face the difficult balancing act between ensuring national security and protecting human rights and freedoms. That being said, the Maldives Constitution does serve as a strong safeguard for human rights. Moreover, an anti-terrorism bill was drafted in 2008 designed to ensure that Maldives legislation on this issue is fully in line with our international obligations, including those derived from the ICCPR. Non-discrimination. Under Article of 17A of the Maldives Constitution, everyone is entitled to the rights and freedoms prescribed within it, without discrimination on any grounds, including race, national origin, color, sex, age, mental or physical disability, political or other opinion, property, birth or status, or native island. We acknowledge, however, that the existing secondary legislative framework in the Maldives needs to provide further protection on equality and non-discrimination, and this is an area where much legislative work is needed. The rights of persons with disabilities. Under the 2008 Constitution, discrimination based on mental or physical disability is prohibited. In addition, a bill was enacted in July 2010 designed to protect the rights.
Could the speaker read more slowly, please?
Principles and procedures for providing protection and financial assistance. Gender. We are pleased to report that significant progress is being made towards gender equality. The Maldives continues to rank highly on the Gender Development Index and Gender Empowerment Measure. Building on this progress, earlier this year, President Wahid created the new Ministry of Gender, Family and Human Rights, which will tackle discrimination among all vulnerable societal groups. In conjunction with the National Gender Equality Policy, which aims to promote substantive equality through gender mainstreaming and specific actions designed to advance empowerment, the government of Maldives is developing a new legislation to enable it to meet its obligations derived from the CEDAW. Steps have been taken towards the creation of a women's rights bill. Work is underway to ratify ILO Convention C111 on discrimination in the workplace. With cross-party parliamentary support, the Domestic Violence Act was enacted and a sexual harassment bill is expected to be passed by the end of 2012. As is set out in our response to question 5, in conjunction with the aforementioned anti-discrimination provisions, steps have been taken to improve the status of women in the public sphere. Crucially, the bar that previously prevented women from running for high political office has been removed. In addition, the Maldives' first female judges were appointed in 2007 in the face of strong criticism and opposition. Moreover, legal mechanisms exist designed to protect against discrimination and to promote women's rights in the workplace. Article 4 of the 2008 Employment Act prohibits inter alia discrimination in the granting of employment and determination of remuneration based on race, color, social standing, religion, political belief, affiliation with any political party, sex, marital status, family obligations, age or disability. Under Article 43 and 44 of the Employment Act and Article 165 of the Civil Service Regulation 2010, female workers in both the private and public sector are entitled to maternity leave. Nevertheless, as in most countries, women continue to face de facto discrimination in all spheres. Unfortunately, negative gender stereotyping is institutionalized and continues to pose significant challenges for gender equality. Moreover, inheritance and on matters of testimonies with regard to adultery, finance and inheritance. Maldives maintains a reservation under Article 16 of CEDAW with regards to inheritance and has no plans to remove this reservation. State of emergency and the death penalty. Since the ratification of the 2008 Constitution, the provision on the states of emergency has not been invoked in the Maldives. In response to the committee's eighth question, I would like to make it clear that the current moratorium on capital punishment still stands. The bill referred to is a proposed amendment to the Clemency Act and was proposed by a private member with the view that capital punishment could serve to reduce the violent crime rate, which has been steadily increasing in the Maldives. Prohibition of torture. As requested in question 9, we have presented in our response document information on the complaints received by the Police Integrity Commission related to incidences of torture and ill treatment. As is clear from these figures, pages 9 and 10, the number of complaints received by the PIC has increased dramatically since 2008 as the institution has developed. The Police Integrity Commission is mandated to investigate complaints of police misconduct, brutality, and disregard for the law. Where the Commission finds evidence of such wrongdoing, it sends the case to the Prosecutor General's office. Torture and other cruel, inhuman, or degrading treatment is a criminal offence in the Maldives, and the Commission gives priority to investigate such cases as well as wider incidents of police brutality. In January 2008, 2 policemen were indicted for beating and torturing a man in custody. The Police Integrity Commission is currently investigating 3 other allegations of torture. It is also noteworthy that the Police Act makes it easier to dismiss officers found guilty of serious misconduct. Since the Act came into force, 97 officers have been dismissed. Violence against women. Violence against women is a key challenge to human rights in the Maldives and one which the government is fully committed to tackling. While the number of cases of domestic violence reported and investigated has increased, we are well aware of the fact that the number of cases lodged does not accurately reflect the scale of the problem. The implementation of the Domestic Violence Act, it is hoped, will increase the willingness of women subjected to violence to press charges against the perpetrators of it. In response to the concern expressed by the committee, it is not correct that in cases of rape and sexual violence, it is necessary to have two male or 4 female witnesses. In the Maldives, reservations are held against certain Sharia principles, including those related to witness testimony given by women. Under the 1972 Law on Women's Witness Testimony, Law number 14/72, a woman's testimony has equal value to that given by a man in all cases except for premarital sex or adultery cases. Moreover, in rape cases, in contrast to cases of extramarital sexual relations, an individual can be convicted if there is sufficient evidence as per any other crime, including forensic evidence and the testimony of expert witnesses. The government is determined to address both the prevalence of violence committed against women and the issue of impunity for those who perpetrate it. In February 2008, the Maldives sentencing guidelines were amended to ensure more appropriate punishments for violent sexual crimes. More recently, the domestic violence bill drafted by the women's wing of the DRP party in conjunction with various NGOs and UN bodies were enacted in April 2012, and a bill on sexual harassment will also be submitted to Parliament for approval this year. Training and awareness programs for the police and other public servants, including judges, regarding sexual assault, domestic violence and child abuse have also been implemented. Corporal punishment. Under Maldivian law, corporal punishment is prohibited in homes, schools, and within the penal system for any person under the age of 18. Additionally, the Maldives has identified key actions and measures necessary to prohibit all forms of corporal punishment in practice, including legal form, and an anti-corporal punishment campaign is planned for next year. In respect to adults, although the Maldivian Penal Code does not stipulate flogging as a punishment, it is administered in exceptional circumstances due to the prescription of this punishment under Sharia. The government is currently examining ways to address the current discriminatory application of flogging, which should be partly countered by the government's efforts to decrease the reliance on confessions in legal proceedings. Liberty and security of person, arbitrary detention. The Maldives police has legally detained an individual can legally detain an individual up to 24 hours. After that, a court order is required to extend the period. In practice, this is strictly adhered to. It is true, however, that the previous government contravened this law on a number of occasions by detaining political opponents. When Mr. Yamin Abdul Gayoom, MP, was arrested and detained in July 2010, pressure on the government led to his release. However, again in 2011, the previous government arbitrarily arrested a number of political figures, including the current Home Minister, as well as the Chief Judge of the Criminal Court. The present government has given its full support to relevant institutions to uphold due process when making arrest and detention. Investigations focused on obtaining confessions. As I mentioned earlier, Maldives is seeking to move away from a criminal justice system based on confessions. Under Article 52 of the Constitution, confessions made outside of a trial hearing in a court of law are inadmissible. The government is working hard to ensure that this occurs in practice and that legal hearings are based on tangible, factually accurate evidence. To this end, a new evidence bill and a private member's bill on the prevention of torture are currently tabled before the Parliament. Prison conditions. The problem of non-segregation mentioned in the committee's 14th question is one that the Maldives has successfully addressed. It is no longer the case that juvenile prisoners are accommodated alongside adult detainees. Furthermore, accused persons are no longer kept in the same facilities as those already convicted. Regarding prison conditions, while it is true that all the Maldives prisons now meet the minimum standards recommended by the National Preventative Mechanism, it is undeniable that the system is inadequate and overstretched. The prison and payroll bill, due for tabling shortly, should serve as a vital tool in improving the conditions in Maldivian jails. In response to the committee's query, the Addu Atoll facility is no longer in use. It was closed immediately on the recommendation of the NPM in 2010. Legal aid. According to Article 53 of the Constitution, every person has the right to retain and instruct legal counsel in any instance where legal assistance is required. Currently, the state provides legal assistance for persons accused of serious crimes who cannot afford to have such support. A legislative bill on legal aid is in the drafting stage, which seeks to expand this provision. Independence of the judiciary. The 2008 Constitution established the judiciary as a separate and independent branch of the state. This was a significant step. However, this independence and separation of powers has been challenged over the last 3 years. The current administration wishes to restate its commitment to upholding the principle of independence and will endeavour to continue to build on the positive steps made with the adoption of the Constitution. That the Maldives judicial system is in its infancy possesses a problem. Lack of trained lawyers and jurists persists. Similarly, while there have been new additions to the benches of the superior courts and appeal courts, generally speaking, the majority of judges require further training and resources to effectively undertake their role. This is highlighted in our response to question 17, along with our approach to tackling these issues. We are seeking to enact legislation, including the new Penal Code, the Criminal Procedure Code, the Evidence Bill, and the Civil Procedure Code. The establishment of a judicial training institute is also a central aim. Reforming and strengthening the Judicial Services Commission is also a priority goal in order to support judicial independence, integrity, and impartiality. Elimination of slavery and servitude. Human trafficking. With the assistance of the Australian government, we are working on the preparation of a draft bill to prohibit and punish all forms of trafficking in persons. In addition, the Department of Immigration and Emigration has published its Human Trafficking Action Plan for 2011 to 2013. Under this plan, an anti-human trafficking unit was established. Further measures to protect potential victims of trafficking are in the pipeline, including a 24-hour helpline, language training, and the establishment of a victim support unit. To help support this and other work, on 5th August 2011, the Maldives signed a cooperation agreement with the International Organization for Migration and became a member of the IOM on 5th December 2011. The Maldives is currently in the process of completing the internal procedures to become a party to the UN Protocol to Prevent, Suppress, and Punish Trafficking in Persons, the UN Convention on Transnational Organized Crime, and is in the process of ratifying the Co-International Labour Organization conventions. During its UPR, the Maldives also committed to consider signing and ratifying the International Covenant on the Protection of the Rights of All Migrant Workers and Members of their Families. Freedom of religion. I now turn to the key issue of freedom of religion. Article 10 of the Constitution states that the religion of the state is Islam and that Islam shall be one of the bases of the laws of the Maldives. The Maldives maintains a reservation to Article 18 of the ICCPR and has no plans to remove it, nor to change laws prescribing that holders of key public offices be Sunni Muslims, nor that citizens be Muslims. As the Maldives is a Muslim nation and it is a prerequisite for anyone seeking Maldivian citizenship, there are no provisions in the Maldivian law for the practice in public of other faiths, the building of places of worship of other religions, or the import of religious icons. Nevertheless, non-Muslim foreign residents are permitted to practice their religion privately, and the import of religious literature, for instance the Bible, is permitted for personal use. Freedom of opinion and expression. Freedom of opinion and expression are constitutionally protected in the Maldives. The government is committed to uphold these freedoms as well as freedom of assembly. Madam Chair, I hope I have been able to touch on all the concerns and the questions posed by the committee. I request that you take my comments as they were intended as a summary of the responses we have submitted more fully in writing. I thank you, Madam Chair.
Thank you. First to the head of delegation, Minister Ahmed, for the opening statement that you presented, as well as the information, the background information on the context in which the provisions of the covenant are being given effect in the Maldives. And of course, I thank Her Excellency, Ms. Adam, for the summary oral replies. So now we are at a stage where members of the committee will ask questions, ask for clarification, make comments on some of the issues in the list. For this afternoon, we will concentrate on issues 1 to 11. And so I will call upon members of the committee to address themselves to these 11 issues, after which we shall give the delegation time to prepare for your responses, something like 15 minutes. And then we'll come back to listen to replies now from the delegation. So for now, I call on Mr. O'Flaherty to take the floor.
Thank you very much, Madam, and I'd like to join with you in warmly welcoming the delegation. Engaging in a dialogue in the context of an inaugural report is always a very special occasion for this committee, and an important acknowledgement of the role that the Covenant should play for states. I welcome also the fact that the State Party ratified in 2006, together with the optional protocol. This is welcome. And I'd have to say that in the practice, that this committee sees, the state is not even very late with its report. It's a reasonably timely submission of the inaugural report. What is it now, 18 months ago, after a ratification in 2006. I think also that it's a good delegation before us. I think if you look pro rata at the number of the delegation 4 relative to the population, it's a reasonably large delegation when we think of some delegations from much larger state parties that we occasionally engage with. Finally, in terms of welcome, if you'll allow, Madam, I'd like to welcome civil society who've travelled here to give their views and have been very helpful and very constructive and very well organised, as well, of course, as the representative of the National Human Rights Institution. Now, I have just a couple of general remarks before getting to one or two specifics on the list of issues. The first general remark has to do with the report that's been tabled. It's an interesting model. A core document that then attempts to cover all the rights. It's not one we're used to. Another state party presented something like this a few years ago, and the committee was not very pleased and made that clear to the other state party. I'd have to say that it's not the best model to do our job. A number of years back, the treaty bodies adopted the view that an integrated report was not a good vehicle to deal with information under all the treaties, that we do need distinct documents side by side with a good sturdy core document. Here we have everything in the core document, and that does reduce the focus. Curiously, I've read the core document with interest. Civil and political rights are actually rather well dealt with there. If we were the Committee on Economic and Social Rights, Social and Cultural Rights, I'd be even more concerned, because they do seem not to have been given the same amount of attention in the core document. But in terms of model, we'd encourage the state party to go back to the more normal framework, unless they were to adopt the list of issues procedure, which we have as well. But let's not overcomplicate things now. I would also wish to welcome the response to the list of issues. It did arrive rather recently, but it's in many ways very elucidative and helpful in terms of getting a sense of the situation. And it was, I think, gracious of the delegation to apologise today for the delay, and I think that's very well received. By way of general and final general observation, I have to, of course, acknowledge that the list of issues was drawn up in 2011. And as the delegation itself has conceded, there have been some rather dramatic developments in the state party since then. And inevitably, if we're to be relevant, we're going to have to engage around some contemporary issues which couldn't possibly have been captured in a list that was developed in 2011. And I'd like to assure the delegation that colleagues will engage there, and you'll understand the extent to which it'll be necessary to go beyond the list of issues in the light of the circumstances. And now, I would turn to just two of the points in the list of issues. Points 1 and 2. The first point in the list sought information with regard to the status of the covenant in domestic law and practice, and you've been very forthright in providing the information there. I must say it was good to hear the oral presentation today, because the reply to the list is somewhat over-succinct, where it actually says the provisions of the covenant cannot be treated as law in the Maldives unless incorporated. And of course that could be misread to somehow give the impression that you don't consider the covenant to have the status of law. Of course it has the status of international law, but the distinguished ambassador made the point clear orally, so that's sorted out. What does concern me, though, is the suggestion that it has been adequately domesticated through the Constitution. Because I've been looking at the Constitution, and I do have some concerns. For example, I'll give you two. The non-discrimination provision in the Constitution at Article 16, paragraph C, which lays out the grounds of the impermissible grounds of discrimination, and it does not include language and religion. And so clearly we cannot say that the covenant is adequately domesticated through the Constitution if there isn't a prohibition on religious-based discrimination. Now, I'm not even going to the reservation about which we've already heard some commentary and which we'll come back to. That's not my point here. It's more the domestication of the covenant. And I see one other faith-related element in the Constitution which causes me pause for concern, and that's the provision in the rights section of the Constitution, whereby, and I quote from the Constitution, "The limitation of a right or freedom specified in this chapter by a law enacted by the People's Majlis as provided for in this Constitution, and in order to protect and maintain the tenets of Islam, shall not be contrary to the Constitution." Now, that's a sweeping provision which leaves me at a minimum with a question as to how you can better explain to us that the Constitution does adequately domesticate the covenant. And I'm sure colleagues may have some other issues of the Constitution as we proceed. Otherwise, it's no novelty to this committee to engage with a state that has a dualist model. There's no rule saying you must have a monist system whereby the covenant is directly implementable. And likewise, it's not a novelty to have a judicial system that is not constrained by the treaties. But in most such jurisdictions, the judiciary is quite open to having the treaties pleaded for persuasive purpose. And I'd like to know if any efforts are being made by the Maldives to promote the use of the treaties, the covenant, in our context, in the courts, to persuasive effect. If the response is you haven't done it yet, the question then would be, would you consider it, and would you consider paying appropriate attention to the covenant in the proposed judicial training programs that you've referred to? Moving on then to question number 2, and this concerns the National Human Rights Commission. There I think we got a really good answer from you in the reply, paragraphs 2 to 11. It's very detailed, and there's a very strong commitment to a strong national human rights institution, which we can only welcome. And it's generally very informative. And by the way, I think it is very encouraging, and it would be good if other governments also would do so, whereby you are seeking the support of the Office of the High Commissioner for Human Rights in this context as well as in others. And again, I think that's to be encouraged. But of course, we do have the problems that have resulted in the Commission only having B status with the International Coordinating Committee.
It's 19 hours.
You think it's unlikely that such a thing would ever come to pass. That's what's said essentially in paragraph 10. It would be really encouraging today to hear from the government that it is determined to ensure that non-Muslims can and may even be appointed to the Commission. And, in one fell swoop, you'll do away with the problem of the B status, it seems to me. The crediting committee have a lack of resources. I'm not convinced on that point. I think pro rata for the size of your population $1.5 million is a generous budget. So I'm not engaging with that dimension of their concerns. And Madam, in the first half, since we're only dealing with questions 1 to 11, that's it from me. Thank you very much.
Thank you, Mr. Flaherty. I now give the floor to Mr. Salvioli. Mr. Salvioli, you have the floor.
Muchas gracias.
Thank you very much, Madam Chairperson. Allow me to add my name to those who have congratulated this sizable delegation present here. It is always a pleasure to receive an initial report from a state party. I am responsible for those aspects that are non-discrimination related, so I'm sure this is going to be a very fruitful debate that we will have. But I am going to be very sincere from the point of view that we need a constructive dialogue, and that both the state and the committee wish to better protect the human rights of persons in the state party. And it is with this frank approach that I would like to address the state party. I welcome the progress announced. I have read in detail the replies to the list of issues, as well as to